Folks, welcome to another edition of my video blog. Today we're going to talk about a crime that's becoming more and more common, and that is cultivation of marijuana. Now, the state of Maine looks at the number of plants you're growing to determine whether or not it's a misdemeanor or a felony case. For example, if you're growing less than 5 plants, it's just strictly a misdemeanor. Between 5 and 100 plants, once again, it's a misdemeanor. However, when you hit that magic number of 100 plus plants, you are now in the category of a felony offense. Now, why is this important? Well, you might be close to the number, and what's important to remember is it's the number of root systems that those plants are attached to. Now, common questions that I get from people are, well, what about the sex of the plant? Whether it's the male or the female, some of those plants cannot actually be harvested for the marijuana for whatever reason. The sex of the plant plays no determination in the analysis of whether or not it constitutes a plant with its own root system. Nor does the maturity of the plant. If it hasn't shown a sex yet, it's still considered to be marijuana. But what if it doesn't have, don't they look at the yield from those plants to determine whether or not there should be a felony or not? Absolutely not. They only look at the number of the plants. When you have a prior conviction for a drug offense, such as a drug trafficking offense, or you have weapons in the home, you are facing an aggravated cultivated charge. So what that means is whatever your felony would have been, maybe it would have been a C felony, or whatever your misdemeanor would have been, it gets bumped up one level. So if it was a D misdemeanor because you had more than 5 plants but less than 100, it's now a C felony. If you had a C felony because it was between 100 and 500 plants, it is now a B felony. And the penalties between a Class B and a Class C offense are wide apart. They are very serious. Same difference between a misdemeanor and a felony. Big difference when you start talking the felony level rather than the misdemeanor level. Common things or common themes that occur in these cases are, do the police need a search warrant? Can the person in the house that lives with me authorize the police to search the house? Can my roommate allow the police access into my room to search it? Can they search my vehicle? There are a lot of search and seizure issues that come up in these marijuana cultivation cases. Oftentimes the marijuana is grown outside, especially when we start talking about large quantities of plants, but there are a lot of growers that try and grow these things in the basement, in the attic, stuff all those plants in, and then the police are then having to go and get a search warrant. One other thing that comes up quite frequently is, can they do a heat scan of your house? Because when you're growing, you have these growing lights to grow your marijuana plants. It's giving off an enormous amount of heat, and there are certain scanning devices that can pick that up. That's a question or a topic for another discussion for another day, but it is quite common, and it is a question that does pop up. So if you've been investigated for or charged with cultivation of marijuana or aggravated cultivation of marijuana or any drug crime for that matter, please pick up the phone, call my office. I'd love to speak with you about the case. This is an area that I'm very comfortable practicing. I enjoy doing drug defense cases. There are a lot of nuances to it. You really need to understand not only the case law, but how the factual scenarios can play out, either to your benefit or your detriment. Again, if you've been charged with a drug crime, please call my office, and I look forward to speaking with you soon. Thank you.